Hello, in this webinar we will briefly cover the law, your legal responsibilities, risk assessments and training, and what resources are available to help you. As the business owner, you have ultimate responsibility for the health, safety and welfare of your guests, staff and contractors. The buck stops with you, not your staff, letting agents or anyone else. Before using a hot tub, you will need to read and understand the relevant law, in particular the Health and Safety at Work etc. Act 1974. This is the overarching piece of legislation under which other regulations, codes of practice, health and safety guidance notes etc. are made. This sets out your legal duties, e.g. the safety of plant and equipment, provision of information, instruction, training and supervision. The Management of Health and Safety at Work Regulations 1999 requires you to carry out a risk assessment. The Control of Substances Hazardous to Health Regulations 2002, which is known as COSH, provides a duty to assess, prevent or control the risks from exposure to hazardous substances, including chemicals and biological agents such as Legionella, and to take suitable precautions. Other laws around electrical safety will also apply. In addition, there are two key specific industry guidance publications. HSG 282, Control of Legionella and Other Agents in Spa Pool Systems, is produced by the HSE, the Health and Safety Executive, and is available free online or to buy. And in addition, Hot Tubs for Businesses, which is produced by the Pool Water Treatment Advisory Group. This is a priced publication. Both publications are clear and concise, and in the case of HSG 282, pages 34 and 35 set out details of how you are expected to keep your hot tub safe and clean. The links for these publications are provided with the resources attached to the webinars. To clear up any confusion, whilst both of these publications are guidance and not the law, if you follow these, you will be able to demonstrate due diligence, and that as a responsible operator, you did everything expected of you to provide a safe facility for your guests. In the event of legal action, if you have not followed this guidance, the first question you will be asked is why not? And the second is what equivalent measures have you taken? Also, be aware that your insurers will expect you to follow available guidance, and they may not cover you with insurance if you do not. There are occasions when you may receive a visit or contact from your local council enforcement officer. This is either routine or as the result of a complaint. They have a right to inspect, even if there has been no complaints. They also have powers to require improvements and, in extreme cases, if advice and support doesn't work, to prohibit the use of your hot tub. Fundamentally, you must consider and assess all the risks that your hot tub and its environment faces, in the same way that you are required to produce a fire risk assessment. The easiest way to show compliance is the completion of a risk assessment. There is an example of this in the toolkit. Some examples of the risks to consider are poor water quality, which can lead to Legionnaire's disease, folliculitis, which causes a rash, E. coli, which causes stomach bugs and other diseases, slips, trips and falls, chemical use and storage, drowning, entrapment, where hair is sucked in. Please watch our series of webinars to hear more about these risks. Every business is different, therefore there is no one-size-fits-all in terms of risk assessments. Yours must be tailored to your business, and you must review it following any changes or incidents. It's a good idea to get into the routine of reading all of your documents every year. Have you considered everything that is reasonably practicable to reduce the risks to a level that it is acceptable? Can you provide evidence of control measures which should be suitable and sufficient, monitored and enforced? If you have 5 or more employees, your risk assessment must be written down. So yes, if you don't, then you legally don't have to, but we strongly recommend that you do this, because how else will you show to your guests your local enforcement officer, your insurers, and ultimately a court of law that you run your hot tub safely. Many insurers will ask for this to be done as a condition of insurance. Writing it down is the best way to protect yourself, your business, and your business's reputation. So if you've taken the time to do the assessment in your head and think about it, then why not just write it down? The outcome of your risk assessment will inform your procedures. These are typically the normal operating procedure and emergency action plan. Again, details of these can be found in the webinar. Last but not least, training. You have a duty to train yourself and your staff so that you are all familiar with the law and guidance. Anyone carrying out any task must be competent to do so, and all necessary instruction and training to ensure this must be carried out, e.g. the handling and storage of chemicals. It is for this reason that you cannot ask your guests to deal with any chemicals in relation to your hot tub. You might want to consider undertaking courses or getting specific help from a recognised specialist. Further information can be found on the resource section. In the next webinar, we will run through the operation and maintenance of your hot tub.